It's 8 o'clock. Start without him. Fuck him. Fuck him.
That is really kind of prima donna-ish, to be honest.
Yeah.
You know, there is somebody out. Oh, good afternoon, Kurtis.
Good afternoon, guys.
What's the hat?
It's Hurley. It's a Hurley hat.
Hurley hat. Okay. I thought it was a New York Yankee hat.
No.
Okay.
No, I'm an Atlanta Braves fan, so that's
all right. They're off to a good start this year, right?
Oh, no.
Yeah, I know. I'm aware of that, by the way.
Okay, yeah.
And what's the T-shirt say?
Oh, this is for Savvy. This is
Junk.
Yeah,
nice.
Junk.
Nice. Yeah. Who's that? Just so if somebody doesn't know who you're talking about, who's that you're talking about?
That would be Julianne on X, who hosts so many MMTLP spaces.
Yeah, she wakes up very early. That's all I know.
Yeah.
I don't think she goes to bed.
Very possible. So we're here with Kurtis, JR, and I, and we're going to talk about. Obviously we're going to talk about MMTLP, but a bunch of other stuff. I'm sure Kurtis, who's had a ton of time to prepare for tonight, is ready to talk about all kinds of things. I may even prod him on some things, so we'll see. We'll see what he does. And JR, he's in such good spirits. I'm just kind of awaiting his magical tunes tonight. Looking forward to it. You know what? Please don't rely upon anything that is said here because it's not very reliable most of the time, except for Kurtis. Kurtis is trustworthy, but I can't say that much for JR and myself. Before we start, and this is the first time we actually are sponsored tonight. We haven't been sponsored before. Usually the most we got was I think we got a pack of gum once. No,
Get to the punchline. Get to the punchline.
We got two sticks of gum. So tonight we're sponsored by Jimmy's Kitty Litter, where our goal is to make your worst room smell better than FINRA's. Also, Sammy's House of Radishes, where being an American means eating radishes. And by Julio's Soap Pies. Yes, Julio's Soap Pies. If your kids act out, you can feed and punish them at the same time at Julio's Soap Pies. Anyway, so thank you to our sponsors tonight, first-time sponsors. Now, part of what we're going to talk about, Kurtis, is those new documents. I don't know if you've heard about them.
I have.
Okay.
I have heard about them.
So when you first saw them or heard about them, what was your first thoughts?
I saw the initial page count and I wondered what the juice was inside. We've had more than one FOIA release. A lot of people within MMTLP, and we've been submitting FOIAs since really January in a concerted effort, January of 2023.
Let me stop you there. So
yeah.
I think I saw something that said there were like 600,000 pages of documents that were responsive, I think, to the request. Now, yeah. I don't think like 600,000 pages have been produced. Maybe 600 pages, maybe. I don't even think that much. But I was thinking about that. There's a Freedom of Information Act. If you don't have access to the information, then what is it? I mean, to the public, there's no like central summary where you can kind of decide which documents might be relevant or you want to copy. There's no way of tracking them. It would seem like that's not really a complicated technology, just a matter of, imaging a bunch of documents, creating some kind of indexing system, and then letting anybody have access to whatever is publicly available. Because I think right now it's not accessible. So anyway, sorry to state that, but go on.
No, it's really important context. And the community has done a fantastic job of submitting these FOIA requests. But to your point, all but a handful of them have been denied. And actually really great context. A FOIA that has not even been discussed publicly yet was granted, I believe Thursday or Friday last week. So not this one that we're going to be discussing. And it was granted in full because it was asking for the public public log of all related MMTLP, Nextbridge Hydrocarbons, Metamaterials Inc., all the related companies. And that is actually a publicly accessible information that you can download. If you go to the relevant agency, you can filter and look at the individual logs, and it'll kick out a CSV file. But they actually filtered it down. And when you look at the number of requests, still need more time to vet through that. But the number of requests, if you just look at the public log on any given month, really since December of 2022, when MMTLP was halted, MMTLP makes up a majority most months of the FOIA requests, which is crazy. It's something we should be proud of. And then also it's a black eye for transparency, like you said, because it is so difficult to get one of these through, and to be specific and nuanced enough that you can get a timely result, but also they use the 7A exemption constantly. So
yeah, we know that one. I mean, I don't know this for a fact because I don't know much, but after those documents were released to Howard, it seemed like they took a pretty strict view of any ones after that. So I don't think they operated in good faith. I don't think they no. I mentioned we could go through their staff and ask them if they've reviewed the 600,000 pages, and the answer is going to be no, they haven't. They just elected to take a very strict position. And, in reality, and JR and I have talked about this, in reality, what's the worst that can happen? They don't produce, then you appeal, they say no, and then you actually have to file an action, a legal action in court. So if you get to that point in time, maybe they'll produce at that point, maybe. Or they'll
remember, when you file in federal court, they have to, and I forget what the threshold requirement is, but they have to prove to the judge whatever exemption they're using. Now, it's typically an in-camera meeting, but they have to go through it. The burden, once you file that FOIA lawsuit in federal court, the burden shifts to the government, and now the government has to put on the case to the judge and show that they've met every one of the exceptions. Now, the 7A exception isn't in perpetuity either. Most people don't realize that at some point they're not going to be able to use that exemption anymore.
I think in the document, and Kurtis, I haven't really studied the documents at length, so I just kind of looked at them and got, whatever popped at my head. But I do remember something in there saying that, and I may be wrong about the date, but something like June of 2024, they said, I think it was the SEC, referenced that there was still some ongoing investigation. Yes. So, yeah. So if that's the case, it probably carries over till today's date. It could be, the Berta Palicaris, that could be an investigation, could be a bunch of other things. But I think that's probably one you can't win on because there actually is something. I think the problem is it's not exercised in good faith at any, and most times. Most of it's an easy way of responding without responding, complying with the law, arguably, but not producing anything in reality.
Well, I think when we get into the content, and I did send I don't know, 7 minutes ago or 7 minutes before we started, I did send the non-redacted version of this FOIA release to both of you. So we can go through what I think are some of the most important pieces. But while we talk about all of the excuses, because I think that's what it is, but when we talk about the exceptions and the reason that they are not providing these FOIA releases, and there's actually a really interesting memo in here, and we'll point out an SEC statute that is referenced as an excuse to not provide some of the information to Congress, but then simultaneously, and we'll hopefully get into the details behind this, but inside of this FOIA release are memos from the SEC, and just so I get his title correct at the time, he served as chief counsel for the SEC for legislative and intergovernmental affairs. He was working directly with Congress, and is making suggestions of meeting for coffee a week before the press release. Right. And obviously the charges were formally publicly filed against George and John, but is actively advocating. And then if there was any level of doubt, he then, after the press release is distributed by them, by the SEC, directly to Congress. He then says, now you know why I wanted to get coffee.
Right.
So leaving literally no doubt. So
right.
Yeah.
And my personal opinion is that's a big fucking problem for them. And I hope Berta and Palikaris are going to the court or talking to their attorneys and getting those guys, because that's a real issue. You can't do that. Not when you have a sitting congressman who, for all intents and purposes, had drafted a letter demanding certain information, and now all of a sudden the charging agency has coffee with that congressperson, and then that congressperson goes out on national news or wherever he was on and basically does a 360 and bashes Berta and Palikaris.
Yeah.
That's not a good. First off, it's not a good look. Doesn't have good optics. And secondly, I think it's pretty damn close to obstruction of justice. That's my own personal opinion.
Are you going to be testifying as an expert in this case?
I'm fucking testifying as an expert.
All right.
Piece of shit. There, I said it. That's a piece of shit.
You said it. All right. I'm gonna take you up
Put
on
it
that.
out there right now.
All right. Before we go further and we talk about the documents, and maybe you can kind of start that way, and we can comment on the documents as you comment, so you can pull them up on your computer or wherever you have them. But I was told and asked by someone to discuss this specifically with Kurtis, and I have to do it, so I will. I know I thought you were a Ram fan, and you're a Matthew Stafford fan, and no, that's what I was told. That's what I was told, and I'm okay. I like Stafford. I would say on a 1 to 100 scale, he's about a 76. I would say, but I think like the most overrated quarterback of all time has got to be like Peyton Manning. I'd say he's got to be at best like a 46, 47 out of 100. My opinion. just my opinion.
Yeah, this would be Jack. Okay, I see right through this. This would be Jack. This is him poking the bear.
Yes.
Yeah, Peyton Manning is my favorite football player ever, and yeah.
I gathered.
Yeah.
I gathered. Yeah. I didn't really mean what I said. So
anyway. Did Kurtis?
Yeah.
You saw who won the Super Bowl, right?
What?
So you saw who won the Super Bowl, right?
We beat the Bears in 2006, 2007.
Before you start, you got the documents open?
I do.
Okay. Before we start, I kind of wanted to. I hear this. I did a video on it, probably, I think, or I bitched about it on a X or a tweet. It's too bad. Like, he bought the company. It's called X, and it's still a tweet. It's never been able to transfer. It's like a generic name now. Like Coca-Cola or whatever. So people talk about, and again, I'm not going to draw any conclusions about. There's claims about prior people and what they did, whatever, and there's claims of misconduct. I'm not going to go into that. I have no opinion, honestly. I wasn't involved, don't know what's going on. My, interactions with those people has been fine, so I have no complaints, but that happened. And now we're talking about our claims about the current time. And I was trying to kind of draw some kind of analogy. What's the analogy? It's kind of like this. So let's say you go, and I don't mean to demean Tesla, but let's use Tesla as an example. Let's say that Kurtis goes to the Tesla dealership to buy a new Model Y. Nice car, by the way. And the salesman lies to him about the price, about the features, about the gas mileage, about the loan terms, the quality, the resale value, the warranty. He still buys it. It's certified by the country as a authorized vehicle you can drive. It's just that it was full of lies in securing the product. 2 years passes, and Kurtis is driving down Pico Boulevard. That's in LA, by the way. He's driving down Pico Boulevard, and he gets T-boned by a Mack truck. The fact that 2 years prior somebody was involved in some scam and selling him the car does not stop him from suing the guy who hit him and T-boned him. And that's the difference. So I think it's a complete distraction, irrelevancy discussion about what happened 2 years ago. What we're focusing on is what happened at the time of the U3 halt. And that is not excused, conditioned upon, or changed by something that might have happened a year or two prior. Obviously, if in fact, and this is kind of like my home run pitch here, if in fact FINRA believed that the reason for the U3 halt was because some guys who were previously involved in the company had defrauded the investors when they issued the U3 halt, they would have said so. It would have been an easy out and done, completely defensible. The reason why they never said it, because it wasn't true, wasn't the reason for the halt. Period. End of story. So everybody out there, don't be confused when people focus on prior conduct. It has honestly has nothing to do with what our task is at hand. So just wanted to state that. Now, and anybody can comment on that, or we can start rolling into the documents. Go for
I would
it.
like to append your analogy, which was fantastic. I've never thought of one. Usually it's asked to do one on the fly, and I love your analogy. But the only thing that you're missing is that there were some police officers that happened to be performing traffic control and directed that Mack truck to T-bone the Model Y.
That's sad.
Yeah. Yeah.
You guys are amazing.
I'm glad you survived, by the way. I'm glad you survived, Kurtis. It's great to
Thank
hear.
Thank you.
All right. All right.
Safest car on the road.
Safest car. Yeah, it is. I guess it is by empirical evidence. All right. So let's start talking about the documents. You can just identify like a date of a document or what it talks about as we go through.
So there's a lot of content. I think the most important, first of all, it sounds intimidating. And for anybody that has not read through, George Palikaris put a Dropbox of the entirety of the FOIA. He did redact some names because he had kind of partial permission and didn't want to, honestly, I think he just didn't want to cause any noise for certain parties without providing some appropriate context. And his post asked a lot of questions and I think had some assumptions thrown in there as well. And I think when you look through the entirety of the 56 pages, the one piece that I know was redacted is JD Vance's office is absolutely the center of communications from really an individual from Mark Ueda, who was until an hour and 7 minutes ago the acting SEC chair. But
I should clarify is that after we noted his appointment, because it happened about within the hour, JR and I invited him on the show tonight. We have not received a response yet, so it's possible he may show up at some point in time.
He has not returned back my calls, but I'm sure he's busy today. You know,
okay.
So we'll see. But I think that is obviously important, and that is redacted in the publicized shared version thus far. It is JD Vance's office, and an individual on the communications between JD Vance's office and Mark Ueda's office is definitely an ally of MMTLP. And so one of the things and part of the justification for redacting that is there's obviously a lot of noise, a lot of probably negative PR that's going to be generated with this FOIA release. You saw it over the weekend.
Can I ask you a question before you continue? So that was a FOIA. Do you know whose FOIA request that actually was?
Yeah, the gentleman's name, he goes by Wally.
Okay, somebody else.
Yep.
And
someone else in South Carolina.
Was that the totality of the response?
Yes.
Okay, thank you. Continue.
Yes, it was granted in full. But the 56 pages actually contains the letter distribution from several letters that have been sent on behalf of the MMTLP investor community from Congress directly to the SEC and FINRA. So that makes up a good portion of the 56 pages. But of those that are not, the JD Vance, Mark Ueda office email is very important. We already alluded to some centralized communications around Ralph Norman's office and what was at the time, I believe Darcy was his legislative director, since I think she's been promoted. But
what's your, by the way, but before I kind of, because JR has a certain position on this gentleman, I don't want to like make sure we don't undercut, you know, what something you might doing. What's your position in terms of Mr. Norman?
Never too late for redemption.
Okay,
that's as nice as I could be. It's never too late for.
Wow, that's pretty impressive, Kurtis.
Why do you think, and JR, you can answer this too. Why do you think people? Because I saw the feedback after this came out, and there was a lot of not nice stuff talking about Mr. Norman or Representative Norman. I should give him the courtesy. Why do you think that people didn't react very favorably to Mr. Norman? I'll go with Kurtis first. I kind of know what JR is going to tell me.
I do too. I sent him a unsolicited red line version of his tweet earlier this morning. But honestly, even when I don't want to come off as ungrateful, because I am genuinely grateful that anybody kind of took upon this effort and made attempts to conduct outreach to whether the regulatory bodies or some of the bodies that they're supposed to regulate, like FINRA, like the DTCC. I am genuinely appreciative of that. I'll just also simultaneously say, in every public appearance, Ralph Norman didn't have his best showing. He was not well prepared, which I totally understand. Of all the topics that a representative in Congress has to be well versed in to speak to publicly, this is an extremely complex scenario, and so I understand getting some things wrong, like calling it a U2 halt instead of a U3 halt, and maybe
he was a fan of the band,
cross-pollinating the Atlas 8, the Atlas Trading Group individuals that were retail shareholders or retail shareholder-driven investment group that were responsible for literally pumping and dumping, and then associating that and cross-pollinating that with the CEOs.
By the way, I'm going to stop right there. So that is what I just referenced before I started. I don't give a shit if X, Y, and Z ripped somebody off. Makes no difference. There was no reason to stop at that point in time. That's one avenue you want to pursue. Doesn't mean that at some point in time we shouldn't examine the end of the transaction. That's to me like what annoyed, I'm sorry to interrupt. What annoyed me was that there was one, it's right in front of me. There's that one dated June 25th, 2024 from Darcy to David Fernandez, Kevin Burris. They're from the SEC. And they're telling her, or they're discussing the SEC charges that have been filed. And there's a response under it. It says, "This is very welcome news. Thanks for the update." Like gleeful that some out has been provided to them. Not that there's any resolution for the shareholders. And again, I had no interaction with her. So I've no knowledge, no nothing. But all I know is that I heard how many times that MMTL people were interacting with those people on behalf of shareholders. It wasn't like super confidential. We knew it was going on. So the fact that she's gleeful that she found some way to terminate it without assisting these shareholders kind of tells you a lot about her and what her ultimate desires are, in my opinion. Anyway, why don't you go for it? Sorry to interrupt.
No. Please, you interject at any point, or else you'll never get a word in edgewise. So,
and JR, I think we didn't give JR an opportunity.
No, keep going, Kurtis. Let's hear your thoughts. I mean, I think everybody pretty much knows mine. I'm sure I'll articulate it a little bit better, but
I think you got it out. I think you got whatever you're holding in off your chest earlier. Was it this morning or yesterday? But so it's not, if we had our pick of the litter, he would not be the person that we would choose to be the flag carrier, right? Because articulating what we are experiencing from a regulatory capture standpoint, being able to speak to the facts, being able to overcome objections, understanding when the regulator is providing you a completely different narrative and seeing through that, and being bold enough to push through and get to the answer. None of that was present with his representation, and that's the biggest shortcoming. And so that's my criticism. The reason I say let's take some silver lining in it as well. They are in many ways entirely dependent on their staffs, each staff, right, in each office, in order to prepare them for their interpretation for what the facts are at hand. And unless they take it upon themselves to go through and do additional research, which I think all can assume that they likely do not do, at least in this case, it was evident that it was not done. You could literally you could experience gatekeeping from a legislative director. You could have an incorrect knowledge transfer from a staff member. There's all kinds of different pitfalls.
Hey,
but
I would say easily manipulated, right? And there's
correct.
Again, a congressperson is busy doing all kinds of crap, right? They can't look at the background of everything. They rely upon people to do a good job. If people are not well intended, then that's so be it. And kind of relates to the issue of defamation, because I know there's discussion about defamation. I'm not trying to get you off track. I just kind of throw it out really quickly.
Yeah.
There was discussion about defamation, but it depends who's saying what and what they're based. Kind of the same issue. If Norman says something, and again, I don't know the specific information, so I'm just making up information. So this is pure speculation, making it up. But let's say Norman said that Mr. X and Mr. Y pulled some scam off and stole $100 million. That was their deal. And he got that information based upon what his legislative person told him. And he had a good relationship. And in the past, the information was accurate. And he had reason to rely upon it. The information may be wrong, but probably no malice, no bad faith on his part. Maybe the legislative person is just a moron. Maybe they're not doing a good job. Maybe they are. Maybe they made an error. Maybe they did it intentionally. There could be a whole slew of things that go in, but that might affect ultimately whether you could bring a case for defamation, because defamation, you have to prove it's false. But if it's a public figure, and I think in this case, Mr. X and Mr. Y at this point in time might be considered that. And in the law for defamation, and there's other issues, but let's just say there's no other issues. In the law of defamation, if you're a public figure, then you have to prove malice, that the statements were made with malice. And so that's where we get to the issue of how somebody learned about the information, and they could have got it wrong. They could have been negligent, but that may not be malicious. So right. I saw a reference, and that's kind of, and obviously I was involved in a defamation suit, never went anywhere, but they are difficult. They're difficult for a lot of reasons. Anyway, back to the scene of the crime.
Yeah, what's JR's opinion? I'm interested in hearing JR's opinion on.
Look, I'm hot about it, but I think there's more to it than just being a jerk right now. My biggest thing about all this is you put together this huge letter. You were pushing for some level of support in Congress. We were actively working with Darcy at the time. I remember it. Because we were coordinating our congressional push, and I was at that point deeply involved in that. And I wasn't having actual conversations with Darcy, but I was talking to the people that were having conversations with Darcy. I can see the missteps and the gafes. Hell, sometimes I get the story confused at times. It's thick, it's convoluted. There's a lot going on. You have to have a heightened level of understanding of the mechanics of all of this to kind of get your head around it. So I don't have any issue with going on television and screwing shit up. Hell, I do it every day here.
Yeah,
My biggest thing is you sat down with the SEC prior to them submitting charges and had a conversation. And then to Richard's point, you were gleeful. It was welcomed news. And that tells me that you had no intent on helping. You had no intent on digging to the truth and finding out the truth. Look, I don't give two shits what Berta and Palikaris did. I really don't. And I've told John that. I don't care. What I do know is George and John didn't oversell the security. George and John weren't involved in manipulating the market and overselling this thing. And I don't give a fuck what anybody says. We know it's oversold. The only thing we don't have are the numbers. The numbers will speak for themselves. So when you take these charges and you use that as cover, that tells me you had no intent on helping, that you were a wolf in sheep's clothes. And then to go out there and put a video about how Jesus has risen and we're all Christians and blah, 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 when you turn your back on your own constituents, the people that voted you into office, you basically said to them, fuck you, I'm not helping you. That to me is the pure definition of a piece of shit. I don't know what else to say.
He's
I
wonder having a hard time communicating.
Norman would have helped wipe the blood and the sweat and the tears off Jesus while he was hanging from the cross, because he certainly didn't help his own constituents.
Yeah, well, I'm not a fan. I'm not a fan of his, but as Kurtis said, listen, this is the way I look at it. I'm pretty open about this. If the guy ends up doing good for me, then I'll support his doing good for me. I may not support him across the board, but if he's going to change his stripes and he's going to now figure out that he got screwed up, then so be it. My concern is, and I think you mentioned it, I'm not sure, but somebody mentioned that the legislative assistant is now at a higher position, right?
That's correct.
Yeah, so that's probably not helpful. It would probably be helpful if that person was at a no position.
I'll refrain from comment on that piece of it, but I will say it can't be blamed. Nothing can be blamed solely on one individual, including Darcy, who was at the time a legislative director in Ralph Norman's office. And the reason I can say that confidently is because we, in many ways, circumvented communications with the legislative director because we felt some friction there. And so,
do you know why?
Do you know
why?
Do you know what? Yes, I know exactly why. I know the truth as to exactly why there was friction there. And
can you state it?
There are adversarial people going through the halls of Congress and happen to concentrate on this office in particular. There are adversarial counterparts.
In English, there's competing interests. Is that what you're trying to say?
Competing interests, correct.
Okay. Gotcha.
Yeah. Which you think would be pulling for the same thing in order to move on with our lives and, conduct a share count and we could all go home, right? But yeah,
right.
It's interesting. It's interesting that not everybody wants full transparency. They just want transparency where they want it, but nowhere else. So
now, one thing, I know we're going to talk about the coffee meeting because we talked about that little off. Before we get that, I kind of want to back up chronologically a little bit. So there's the document September 25th, 2023, the one from Gensler to the Honorable Pete Sessions. By the way, so since we've already gone over Mr. Norman, because I don't know, honestly. I know what JR's position is as to Norman. I don't know it as to Pete Sessions. So what's your opinion as to Pete Sessions in the current time frame?
I think so. I don't know if you've covered this in one of the live streams recently, but there is a bill, HR 2689, that was introduced in the House Financial Services Committee by Lisa McClain.
Yes.
And representative out of Michigan, and
pile of garbage, in my opinion, by the way.
Yeah, it's very generalized. And also the effective date is set 2 years after this would pass as well. But I think that we'll probably be surprised by who signs on, and we could see a Ralph Norman signature or a Pete Sessions signature, and it would not surprise me in the least. And have they always been the best of advocates? Obviously not. There have been a lot of promises, a lot of commitments that haven't been fulfilled. by many of these offices. And, you know, those were the two John Hancocks. They were leading the charge on the front signature page of the open letter. It's their signatures that are first and foremost. And, you know, just going back, Pete Sessions was involved before the halt. And I feel like that is glazed over all too often, but he was involved before we were advocating for his involvement collectively as 65,000 investors or a subset of it. But he has done productive things. Pete Sessions specifically has done productive things behind the scenes. None of it has been publicized in for a while. It's been a long while. So,
and you, JR, you have a position?
Yeah, I do, but you know, I sat in Pete Sessions' office on 3 different occasions. I met with him personally in his conference room. And he, to me, is the quintessential politician. He will tell you what you want to hear right to your face with a very warm welcome and smile. And then the minute you turn around, you're getting 2 knives stabbed right in your back. You know, his office was so combative with us. It was, I mean, I got up and left because I thought I was going to lose my shit on Tucker. Yeah, so I you know, my position on Session is he is not here to help.
You know, about that bill,
I'll
since
leave
we're
it.
talking about, I'm sorry, I don't know if you were finished. You good? Okay. The
Yeah,
bill,
I'm good.
the concern I have was it basically gave enforcement power back to the SEC. I don't think the SEC is capable of enforcement. They don't have the setup. I remember last time I looked, they had 3 administrative law judges. So to really do what they need to do, it's not for them. I really think, and this is what I have been proposing, that should go right to the courts, not in the SEC's judicial system. Go right to the courts. It'll get handled, you know, in an orderly fashion, and in the more as slow as the courts are, it will still be much more expedited than the way that it's set up. I'm good. You know, I agree about getting rid of FINRA or immunity, you know, getting rid of immunity, whatever. I agree with that part. And I would agree if it was less than 2 years, maybe, before it was effective. But you know, that's. I appreciate the sentiment. I don't think it's gonna go anywhere. Just my particular view. And maybe another bill might be introduced in the Senate that might mirror that and might have a better chance. I don't know. We'll see.
Curtis,
I think we all agree.
Hold on. I have a question for Curtis. Curtis, do you think this legislation getting rid of FINRA is because of the congressional push that, you know, MMTLP and retail in general is doing right now, or do you think it's related to Project 2025?
The latter. It's certainly the latter. Is it? Are we making it a more comfortable environment to make that change? Certainly. There's no one out here that's defending FINRA, and that is inclusive, as you both well know, including some of the bad actors that are out defending against FINRA. So, yeah, but I'm not naive to think that we are the reason that bill was introduced. Again, I think the people that sign on to those the offices and the names that you see may not coincide with who have been the most helpful advocates. Picking up on that subtext.
yeah, I get it.
Yeah,
it's the irony is like DJT. You know, you saw their press release this week.
Yes.
And the irony of those, again, I think it's funny. The offshore shorts that didn't report in the United States and apparently didn't exist. So day one they have 10 million shorts. Day 15 there's a transaction involving 6 million shorts. Day 30 there's still 10 million shorts. What happened? Kind of what FINRA told us, right? Goes outside the country, it's gone. As far as we know, it's gone. I used this is my greatest joke of all time. That's the one where JR goes with Sammy on vacation to Mexico. for 3 weeks every year, and every time he leaves the country, the Census Department, they reduce the population of the country by 2. That's the same kind of logic. I think it's kind of absurd, and we accept that.
Why am I in Mexico?
It's outside the country. That's why I needed you to leave the country. That's why I found it, absurd. When isn't FINRA or the SEC supposed to regulate the trading system and keep track, not like lose track? Losing track, I think, would not be doing the job. Keeping track would be doing the job. I think they have an error in logic. Again, that's like another reason why they shouldn't exist. Why FINRAs can exist, but they can go do work in Newport Beach at the beach house. They don't have to be doing stock market stuff anymore. They obviously don't do what they're supposed to do. They acknowledge that. So it was funny to me. The irony is when DJT said this, it sounded, and then they argued about the show list basically, and there's a bunch of irregularities. Kind of sounded like they were listening to a couple of our spaces and went for us. I kind of believe, maybe more than believe, that their interests align with DJT's interest, because they believe they were shorted and a bunch of manipulation. And we heard about this a year ago. I think they're aligned with us, and I'm hoping that their alignment might do us some favor. I know that they're aware of MMTLP, and I know they're aware of our favorite, JR's favorite GTII. But I'm hoping that that's something that they take up. But you have an opinion on any of that?
I agree wholeheartedly. The interests are clearly aligned. I mean, we know that. Nunes, referenced MMTLP in the letter a year and a half ago. But I mean, to your point, we've been barking about all of that stuff for 3 years now.
Kurtis, anything? Because I'm going to ask you about something anyway.
You're going to ask me anyway, so you're going to ask me what I think about timelines at some point, and I think with we could not have timed the stream any better with tonight's news of Paul Atkins getting sworn in, because I think we're likely to start seeing fireworks now from the SEC side, and a lot of the communications within Congress and elsewhere in the administration have been pointing back and pointing to this being, one of the final puzzle pieces before ultimately acting. So, and it makes sense. It absolutely makes sense to have all of the available commissioners in place before doing anything. And it goes back to the pause on further examinations, right, that we saw back in January. So all the
lawsuits that have been dismissed basically since, definitely it appears definitely a different kind of feeling about enforcement and how they're gonna operate. Which some of that might, again, to be honest, some of it might be good, some of it bad. Again, I look at Alpine as the poster child for the bad side. I'm hoping that there's still somebody looking out, but the difference, doing it in a competent way. That's kind of I don't have any qualms with FINRA. If they did their job, I care less. But they don't. Right. They don't. There's no argument. No. So now going back to the documents, the one that I was going to pick out was that September 25th, 2023 letter. And so now we're back to the FOIA documents that we started. There was 56 pages, I think you mentioned. So that letter I found interesting, and I found interesting because they're referencing a prior meeting. So you saw that, right? So when you saw that, what occurred to you when you saw that? I assume you read this page.
I did.
Yeah. So what occurred to you when you kind of thought about that?
Well, a few things. So we only know what we know from the meetings and discussions that we've had in the grassroots congressional outreach efforts that JR participated in. So many people have participated in, and it was interesting how each office approached it, and then also I think in particular, obviously, when Gary Gensler has a couple of moments on live TV where he's providing testimony, where he basically is coy and he doesn't deny any prior knowledge, but he acts as unfamiliar as you could possibly be. And you would assume that there were none of these prior communications based upon his behavior and his testimony, in particular with Mike Crapo and the Senate Banking Committee. And now when you compare that to the emails, the process, the knowledge transfer that clearly took place, and again, the language that's used in some of these emails, denoting MMTLP as a hot topic item, right? And making it synonymous with some pretty infamous crypto.
Ripple, Coinbase.
Coinbase, yeah, Prometheum. So it's it reaffirms what I think we all believed, and that is that Gary Gensler was being completely and totally disingenuous in his responses.
Yeah. How about you, JR?
The thing that surprised me about it all, Curtis, and this is a conversation you and I had, and I remember, because I had called you before I met with Hester Pierce because I wanted to run some things by you, and I used your quote, and I still use that quote today. And it was the old adage: if someone brings a problem to you, what's the first thing you ask? How big are we talking? How big's the problem? And, I think we were a bit naive to think that this didn't make it to the upper echelon of the SEC. I'm more convinced now after reading through this FOIA that they all knew what was going on. They all know the numbers. Pierce, Gensler. I wouldn't be surprised if Norman knows the number or if Pete Sessions knows the number. It wouldn't shock me at all. So I think, going back to that time, we were naive to think that it hadn't reached the level that it did. So I'm surprised, but I'm not surprised because, again, we do this every day. How big? What's the problem? How much is it going to cost? What are we talking about? What are the easy ways out? You know that. So that's my take on it. They absolutely knew.
My take was, and I said this, I don't remember when I said it, but it was just kind of like, part of it is because of what I do. So if you have a deposition, so a deposition is a examination or oath. The attorney questions you. There's a court reporter, and you're in a informal setting, and there's a bunch of questions. Another lawyer can object, but you answer basically questions. Before you step in that room, if you're a deponent, the person who's being questioned, you would meet with your lawyer, and they would go over all that stuff so that when you get in there, you don't like basically lose the case by testifying improperly. And it would be malpractice on the attorney not to prep you for that. So I know I did at least one bad video, probably with horrible jokes that nobody.
Just one?
Yeah, no, this one in particular. And I talked about deposition. So I kind of figured that he had to know, but that was more kind of inferential. Here, the September 25th letter talks about there had been a meeting of staff with Pete Sessions. And one way or the other, either it was before that meeting or after, either he had to sign off on what was going to be said before, or he was told after. One way or the other, he had to be instructed about that meeting. And again, that meeting, if I recall, he's testifying on the 12th, I think September 12th.
September 12th.
Yeah. And we're referencing a staff meeting on the 5th. That information then some counsel, probably general counsel, is meeting with him and then explaining what the hot topics are, which we know the hot topics. And then he's testifying. So I'd love to see the transcript, the written version of the transcript, because because ultimately that's what you'd have to decide upon, the written record. And that's something different than we might hear, if you know what I mean. It might be different. It might appear different in writing than it does orally. But it would be interesting to see if he was just being deceptive or if he was committing perjury. And those are two quite different things. You can't testify falsely in front of Congress, whether you're testifying under penalty of perjury or not. I think it's a felony to testify falsely before Congress, whether you're under oath or not. But I think he was testifying under oath. And again, I'm sure, he's a smart guy. So he's very schooled and skillful, and he would try to be slick in answering the questions. So he may have been deceptive, but not perjurious. So we'd like to see that, but we know for a fact that it was central on his mind at or about the time of that particular hearing, and he had to know. And if in fact he would have testified differently, and this is the question, I don't know. If he would have testified differently and said, yeah, we know it's a big issue. We've been discussing it. It's important to us. We're going to try to work out some type of resolution. We don't know who's responsible, whatever. He elected not to do that. It certainly put a kind of a pause on our momentum, and also kind of discredited the community as a whole, because it suggested we were full of it, in essence, because it was some minimal marginal matter that he didn't even know about. So it's interesting to me, because maybe there's a tort in there. I don't know. But it's something that I know that JR and I will explore, and, might open up new doors based upon the new information. I'm sorry, JR, you were going to say something.
Well, don't forget, he threw FINRA under the bus. I mean, he threw them under the bus. He basically said they did it on their own. The SEC had nothing to do with it. So
yeah, I have the quote.
Won't it be pretty telling if emails come, if a FOIA gets released at some point over the next year or 2 years that shows the SEC and FINRA were having communications prior to the halt? We know they were, but more in-depth conversations about it.
Someone told me, and it's hearsay, and it was probably, it's hard to remember now time-wise, but it was probably, like 4 months maybe after the U3 halt. Somebody told me, who was in a position that had a large investment in this particular entity. They said that they were specifically aware that SEC was pissed at FINRA and wanted FINRA to resolve it. And that was like 3 or 4 months in. So the fact that they now are acknowledged that fact, I think is consistent with what, probably was from the very start, because it's still a thorn in their side as of today. So it didn't go away. I'm sure they hoped, but it did not go away. Anything you want to add about that, Kurtis? That particular.
I think the quote is very telling. Again, the timeline and the timing and what you're suggesting is all reaffirmed what we've believed all along, that Gary Gensler was being coy. But his quote, when Mike Crapo is questioning him, Mike Crapo asked, "Can you confirm that the SEC is reviewing the trading halt from December 2022, and will you commit to publicly releasing the SEC's findings on this investigation?" And Chairman Gary Gensler responds, "FINRA is separate from the SEC, and they have a set of rules that are organized, and those rules are approved by the SEC after public comment. Then they move forward and implement their rules. Under FINRA's rules, they sought a trading halt. They didn't seek the SEC's advice or permission on that. That is something they did separately in that matter." And Crapo comes back and says, "So is the SEC not investigating these actions at all?" And Gensler responds, "The SEC's role is to investigate many things in the capital markets. We don't speak to specific investigations, but we do on a regular basis examine FINRA for compliance with their rules and examine them on a regular basis on whether they are following their own rules as put out to public comment." So on one hand, he points the finger firmly in FINRA's chest. On the other hand, and he didn't know it at the time, I could safely assume, but that statement is very damning, because if they on a regular basis and as part of the FSIO program within the SEC were reviewing FINRA for whether they followed their own rules on this hot topic of MMTLP, they would find that they acted completely outside of the rules with 6490 and how they processed the corporate actions. And the SEC was fully aware of those communications, because that's what's revealed in the first FOIA request in April of 2023. So that they escalated to the SEC suspicions of fraud. So
this is kind of like the stuff, there's a bunch of Supreme Court cases, and JR and I have talked about it, and about that are, seeking to limit regulatory power. We've talked about one that it might involve FINRA and the SEC. And, an argument that's been raised like almost every case we've seen before the Supreme Court is the non-delegation doctrine. And, if in essence, if something really affects the economy, then you really got to be specific in your delegation of authority to whoever. And in this case, it would be from Congress to the SEC. Somehow, FINRA ends up with this key position. Congress does not set foot anywhere near FINRA. There is no supervision of FINRA. And in essence, the SEC kind of says that they don't tell us when they do stuff. So who is watching out for us? Again, that's the design of these organizations. Who is? And the point being, if the concern is that you're not delegating the responsibilities clearly enough so that people aren't going to know what to do, hasn't that been demonstrated? Kind of like, aren't we that perfect example? And probably many tickers. FINRA just exists without any any concern. And again, we talked about immunity, etc. That's in part why they have no concern. Nobody's supervising them, and no civil liability or anything beyond that. Anyway, any comments on that?
I think it's you're right. I think MMTLP is the epitome of the example for, and can provide every use case justification for why FINRA needs to be abolished outright, or at minimum have the regulatory immunity stripped, so there can be some level of accountability. When you think of the origin story of MMTLP, how it existed on a highest level exchange on NASDAQ, and yet circumvented the Form 211 process to review for whether they're actual legitimate assets that are being sold to the public. They circumvented that process, right? Their next utility in the toolbox is the 6490 for corporate action governance. And we know what happened with the corporate action processing and then manipulating the language and the dates. And then they use that same manipulation as justification to halt it. So when given any opportunity, and they were given multiple opportunities over a 1.5 year long period, they chose to protect one side of the house and not the other. They chose to protect their member firms. They completely neglected to take care of investors. And then the worst gaslighting that occurred throughout the entirety of it is after it was halted, and after nearly 100 days, they release an FAQ and they say, well, we had to halt it to protect investors that might have purchased and may not have, their transactions wouldn't have settled or cleared in time.
And again, so I'm going to stop you there. That's 4 months later. They still didn't mention Berta or Pelicaris, right? Still, correct. 4 months correct. Later, that wasn't the reason for the halt or the problem. Right. Yeah.
Right.
So even if you took them at face value, even if you said that they were being completely genuine in that response, they tried to protect an unknown, unquantifiable amount of potential investors, which the broker dealers were all fully prepared to prohibit new buys to open of new transactions. So they were already, broker dealers were already set to protect potential investors.
Yep.
But they elected to protect this unquantifiable variable of unknowing investors versus the known 65,000 population that has been affected since. So it's absolutely asinine.
Do you know if there's been any FOIA requests now from involving like Burris to FINRA? So communications between the specific names. Would you think that would be a good idea?
I have reason to believe that Kevin Burris, Kevin Carson, and David Fernandez have many FOIAs incoming.
Okay. I saw like in one document, I was responsible for 4 FOIAs. I felt very privileged.
That's all. Wow.
4 FOIAs plus I asked for like the blue sheets until I was turning actually blue in the face in a state court, federal court, and an arbitration, and 4 FOIAs. And they said FOYA. They misspelled it, I think. So did you ever meet those people, by the way, Burris, or did you have any interaction with the SEC people directly when you were in DC?
Is that for JR?
That's for you.
Um,
You being Kurtis.
I listened to a phone call with Kevin Burris, but it wasn't with me. But I did listen to a phone call from an MMTLP investor, and I need to listen to it again. It's only one side of the call, so I can't. You can infer a lot, but you can't get the full context without the individual. But I've not spoken to.
From your incomplete review, what was kind of your feel for him?
I think there's some politics, some partisan politics at play. That's not surprising. He didn't seem like the least cooperative individual. He could have been quickly dismissive. So he didn't come off as like a Jack Chase. For anyone who doesn't know that reference, the Phantom FINRA ombudsman, he didn't come off like that at all. I won't go as far as saying he came off as concerned, but he wasn't just immediately dismissive. And that is a lot of the interactions that I've had have been immediately dismissive, and especially from the top of the SEC, for example, they lean very heavily on, well, your community has been violent or threatening at times, which is, even if there are any merits to that, we've talked about it before, but I've received threats. Richard, I know you have received threats in just doing this and just asking questions and just presenting the facts and asking for some transparency. We're merely threatened just for doing that. And yet, we're volunteers. This is not our job in any way, shape, or form. And yet we continue to persist. And those that are empowered to do this as their job, as their primary responsibility, lean on that as a crutch to not engage further, which is bullshit.
Do you think he's still does he still have power at the SEC, or is the new administration you think will replace the old?
Cannot replace all of these individuals yet. We'll see. I think that's on the table for. I'm sure you're following it on whether Jerome Powell can be removed as Federal Reserve Chair as well. So I don't know. We'll see what happens there. But no, Kevin Burris, for example, he's still employed at the SEC in a very similar role to when these emails were occurring.
Just as an aside, do you think that he can? What's your opinion? Can Powell be terminated?
I think it could be very uncomfortable for him, and I think he could be undermined immediately. Can he be terminated? I don't know if he legally can. I don't think he legally can yet, but he can be undermined immediately.
Yeah.
Well, let's take a step back, because I think that's what they're trying to do. I don't think they can legally remove him. Now, they could, if Congress, which the Republicans have a majority in, changed the law. They could easily remove him at that point. But the way the law is right now, they cannot legally remove him. And I don't think that's what they want to do. What they want to do is undermine him, which is happening.
Well,
that's my opinion.
So my view is they have to find just cause, and they'd have to show that he something. But the problem would be, even if they did, the legal proceedings would last more than a year, and he's out in May of 2026 anyway. So right. I think it's useless. I think, because I've heard a lot of people talking about it. A lot of people are concerned that if he gets fired, that it would impact the markets dramatically, especially from outsiders. They would think it would lack stability and independence. But what I heard is one solution is that there's a gentleman that Trump's going to nominate to take over, that perhaps some point in time in the near term, he's going to pre-nominate the guy. And so as opposed to having to fight it out, then Powell will step down early to let the new guy take over. There won't be any litigation about whether he could do it or not. And he's protected the independence of the Fed and moved on. I thought that was kind of an interesting analysis. It might be a way for both to kind of get what they want without there being, any real damage. I just don't know how long that, I don't know if that's true. And two, I just don't know how long that's going to take, but we know we're on a year. We got a year. So interesting to see how it plays out. The other one I wanted to talk to you about was that the coffee chat that you had mentioned. So we're still, now we're going back to the FOIA documents again. So I'm gonna let you take it over from that.
Yeah, let me get to that relevant page, because that's the to me, that is one of the most interesting / damning of the emails. And I'm almost there.
Yeah, I mean, for example, by the way, do you think somebody's asked for all communications between Kevin Burris and Darcy?
Yes.
Yes. Okay. Nice.
Yes.
Nice. Good.
Yeah. So on Tuesday, June 18th, 2024, Kevin Burris, and I don't know if everyone has taken the time to go through and profile each of these individuals, but Kevin Burris still serves at the SEC, and he's had many congressional support roles in various councils on both the Senate side and the House side. But for the last 4 years, he has served as the counselor to the chair and director of the Office of Legislative and Intergovernmental Affairs. And now, since January, with administration change, he is now Deputy Director, Office of Legislative and Intergovernmental Affairs. So he's not, as of right now, removed, despite the admin change. But the email starts off, and this is literally 1 week before the SEC filings against John and George were released and publicized.
You're talking about were you talking about the Beatles?
The what?
John and George.
The Beatles.
Oh, John and George.
John
Yes.
and George. Come on, Curtis.
Yes, I'm sorry. Yes,
Come on.
John and George Harrison. I'm sorry. Yeah, the email's short. It reads, and it's at 11:51 a.m. Eastern. Hi, Darcy. I'd love to grab an introductory coffee with you soon. And this was when I read through, and I'm reading through, and I'm seeing like the same letters that I've read, a dozen times. But I read this, and I was in a hotel room at the time when this was released privately a little over a month and a half ago. And it says, this could be virtual or in person. And I've never once in my career, in my professional life or personal life, had anyone ask to meet for virtual coffee before, ever. Even through COVID, I've never,
ditto.
a meeting, but never virtual coffee. So I'll read it again. Hi, Darcy. I'd love to grab an introductory coffee with you soon. This could be virtual or in person. Are you interested and available at any times next week? Best, Kevin Burris. Again, Director, Office of Legislative and Intergovernmental Affairs at the SEC. And
Stop a second, Curtis.
Yeah.
When you ask someone to meet for coffee, whether it's in person or virtual, that's code for we need to talk, right?
You're going to spill some tea. That's what you're going to do.
We need to talk. That's all that line said. We need to talk.
It says, I got something to tell you.
Yeah, exactly.
And later in the thread, you actually see a week later the confirmation of that. But Darcy did respond to that email and says, hey, Kevin, I'm in the district this week for constituent meetings. And with appropriations on the floor the rest of the summer, I won't have time for a coffee until August recess. Happy to meet then. But in the meantime, I'm really hoping to get some answers and clarity for our constituents on the MMTLP matter that my boss has raised to the SEC several times. So Darcy is being helpful here, right? She is still advocating. And I can tell you that office was still delivering some asks for us that still have not been publicized to this day. But I just don't know if it was genuine, right? On her interactions. And then I'll read, So Kevin responds and says, Kevin Burris responds, got it. Let me know if you free up at any point before the August recess. So nothing immediate, nothing imminent being referred to here. But then the next email is literally a week later, Tuesday, June 25th, 2024, from Kevin Burris at the SEC to Darcy, and says, I hope today's news clarifies why I was inviting you to coffee seemingly out of the blue. I'm sorry we couldn't connect. I'll still look for ways to try to be helpful in the future. David, he's referencing David Fernandez. David will respond to your request as soon as he can. I hope you're doing well. Here's where this is very interesting. I don't know if you two have paid attention, but it's as partisan in DC as it has ever been.
Really?
Right now, in this moment, at least in my lifetime. In my lifetime, I've never seen it as toxic and it's always been toxic. But I think this context is really important to know. They're not supposed to be political affiliations, but technically Kevin Burris rolls up. He's the counselor to the chair. It's an office of the chair position within the hierarchy and the org structure within the SEC. And he took on that position in April of 2021 when Biden was president, right? And Gary Gensler was just then appointed and confirmed as SEC chair. Kevin, again, when you look at his LinkedIn, you look at his background, he served on the Democrat side of Director of Oversight and Investigations and Chief Oversight Counsel for U.S. House of Representatives from 2016 to 2021, immediately preceding his SEC role. He's also worked in support of other representatives. But then the more interesting one is David Fernandez to me. And that is because David Fernandez previously served as senior counsel to the House Financial Services Committee, Democrats specifically, which would have been headed by ranking member Maxine Waters. And so he served, that was his prior role prior to serving with the SEC. He then took on a role as chief counsel for legislative and intergovernmental affairs, obviously working very closely with Kevin Burris. But the interesting part about that is, again, we're talking about a historic partisan DC here. And yet you have political affiliated individuals, Darcy, who is supporting a House Financial Services Committee Republican, a very red-blooded Republican, and conversing back and forth with these two individuals. And I'd be remiss if I did not say David Fernandez is no longer with the SEC. That post-election, and just starting in February of 2025, he is now serving as chief counsel for the Democrats' House Financial Services Committee. Who have, look, I don't want anything to be partisan. I would love support from any and all politicians in getting a resolution and getting this regulatory system straightened back out. But I will tell you, there has been a dramatically disproportionate amount of cooperation from the Republicans versus the Democrats. So it is interesting that, we have had meetings with Maxine Waters' staff, and none of those conversations have been overwhelmingly productive. There have been, obviously, Democrats that signed the open letter. There have been advocates behind the scenes that don't necessarily want their name put out there, that they're assisting in part. But it is very interesting that there was a high level of cooperation between the SEC, which was extremely partisan. I don't think that's not shocking news to anyone, and Ralph Norman's office and Pete Sessions' office.
Yeah. Is there any hint of any special relationship between the two?
There's definitely a relationship, but I'm not going to touch it with a 10-foot
Okay.
pole.
All right. I was going to say we're back to that part about what the source of the information is. So, the SEC might have told Darcy X, Darcy passed that on to Norman, and it may not be accurate. And the SEC may just be, it might be opinion, might be for some purpose, might be for the purpose of, impacting their view. Maybe they, it could have been strategic. I don't know. But so that goes back to, like we were talking about defamation, when somebody acts maliciously. If it's just based on bad information, maybe they should have done a more careful job. That may not be defamation, even if it's not true. So, but kind of, we were talking off before we started, that kind of chummy coffee stuff. It looked a little too chummy. and it kind of made us a little bit uncomfortable, right?
Yes.
Yeah. I don't, not necessarily anything went on or whatever, maybe perfectly legit. It just kind of, I don't know, lacked profession. It didn't seem professional. And, this whole area is, it's full of landmines. So we're more likely to presume if something's going on that there's some negative something going on, because that's been our experience so far in dealing with that. And you're going to add something, JR?
No,
Okay.
I'm listening and reading the comments.
Anything that any other comments about that kind of interaction, the coffee stuff, and that you're feeling about that, or any other documents? Because I think we kind of touched on the major areas of because a lot of it is the copy of the letter, and multiple times. Anything else in there that you want to comment on in those documents?
I mean, the thing that pisses everybody off is welcome news, right? You covered it at the onset, but not as shareholders that have been impacted. It's not how you would want that to be. And I think I don't know, but I'm sure if she could probably go back today after this has been publicized, that she would choose her wording differently. I'm just going out on a limb and saying she probably would like to change the wording on that. But
yeah, she probably didn't think it was going to become public.
What's the old saying? If you don't want to read it aloud in court, don't write it.
Yeah, just again, I don't know what her, I've never met her. I have no context, so I don't know. It just was a bad look for all of us. And again, it's like I'm going to use him out. Like it's like Charles Gasparino. I use him as an example. So somebody again who takes pleasure in other people's misery, in my opinion, is a scumbag. So that's my view. So whether it's female, male, it doesn't make a difference to me. So if she's kind of doing that in a way, then I don't support that. If that's like based on false, wrong information or, inaccurate information, that's a separate story. I don't really know her motivation, so I'll give her the benefit of the doubt. And again, like you said, Kurtis, and this is going to be my last question. Like you said, anybody can be redeemed, right? If they see the light and they help us, then they are our guys. I don't care what happened in the past. They're our guys. We'll support them if they can help us get to the goal line. So, and that was going to be my last question. So from this point, if you're an MMTLP shareholder, what do you recommend they do? And I actually had like 5 things to talk about. We haven't even got through the first. So that's going to be it. But our subject matter. But for tonight's purposes, based upon kind of what we see, based upon like now we have Paul Atkins in charge. If you are kind of giving a suggestion to shareholders about what they could do, what would you suggest?
Well, Congress is the one body that does answer to us for elected officials that we do have access to, right? I think that we've proven that over the last 2 years with congressional outreach, and this administration is obviously receptive, far more receptive than the previous administration. We'll see what kind of traction we get now that all the pieces are in place with Paul Atkins, but I would recommend continuing the congressional outreach, even though it's inadequate for what we want as an end goal of FINRA. I think HR 2689 is a great conversational piece because it does point out that they are inadequate as a regulator, right? Pointing out that they're non-transparent, pointing out that they're opaque. Those are all conversation starters, right, for some of those conversations. But the things that have come, all the meaningful milestones that have come out of MMTLP, I can't really think of any of them that aren't primarily driven by retail investment community. It's community driven events. So whether it was Howard's FOIA back in April of 2023, the FAQ rebuttals that so many people participated in putting out, and getting more information as part of rebutting the information from FINRA, the open letters that we've received that both FINRA and in part the SEC responded to, and then these FOIAs, right? They paint a picture And for me, it reaffirms belief and the other facts that, you know, some of the things are not all publicized, but it becomes pretty difficult, in my opinion, indefensible to not do something about it. When you understand and it's confirmed independently in communications, not from our words, but from their words, that MMTLP is a hot topic. And they're talking about this with, you know, a standing senator who is now the vice president of the United States, right? And the office that's coordinating this within the SEC was until this afternoon the active SEC interim chair. We're talking about high level conversations that have happened, and this is not a business as usual conversation. And yet it has not received the level of attention, and certainly, you know, it's unresolved. It's an unresolved scenario. So I would encourage everyone to do as you both have done and continue to pepper high quality, very specific Freedom of Information Act requests. And the amount of pressure just that the requests generate when they're in flight, but certainly when they are granted. And these communications, they can be really great, and they can be an example of advocacy from some of these offices, and in others, they can be a really big black eye for some of these offices. So, and I think that presents an interesting point of leverage going forward.
JR, did you want to say something?
No.
Okay, that's good. I was going to say also, if anybody out there knows Paul Atkins personally or Devin Nunez, then let us know, and we'd love to hear from you. I was going to say also, before I thank Kurtis, so I'm considering, you know, and we're going to talk about this. JR and I will talk about it. We're not going to do anything that's going to put ourselves in jeopardy in terms of risk, but about what possibly can be done legally in terms of action based upon the new documentation. I don't know how it's going to work out. You know, who knows, but we're going to keep it in mind for everybody else out there. You know, kind of what Kurtis said is just keep it alive, you know, put energy into it. And, you know, again, if you know people, then use your contacts, be aggressive. You know, we all know we have this is not a case we don't know we have a justified position, because we do. Just a matter of, you know, getting some resolution. We have there's somebody new in town. Maybe they'll have a different view on it. Let's just make them aware of it and do it in a nice, professional manner and continue the fight. And again, to everybody out there who shared this with us tonight, we appreciate everybody and everybody who's come out. We appreciate your enthusiasm. If you have any thoughts after this that you think we should consider, put it in the comments after the video. Think about it. And if you have comments, put it there, because we'd like to hear kind of everybody's view, because, you know, obviously we know what we know, and everybody thinks different thoughts. It really might be helpful. Anything? Do you want to add any final thoughts, Kurtis?
No. I think I've said too much already.
And you, JR?
No, I'm good. You know, thanks, Kurtis, for coming on and talking. You know, we appreciate you.
Yeah, I know. It's I always,
even if you're gonna fucking, you know, correct my typos and misspellings, but
yeah,
I would
Go
share
ahead.
my phone right now, but the inappropriate stuff that would come up between JR and I's conversation, I don't know. But it was a text message red line version of his post. So
I expect that, you know, we're going to continue to get documents, and we're going to continue to kind of talk about it. So we're going to continue this conversation again. Like honestly, I had like 5 topics, including like Leonard Leo, I want to talk about, because he's like a really super interesting guy. You got to look him up. You'll find out, super interesting guy in the current time frame. But anyway, I really appreciate Kurtis coming on, and JR, of course, always. All you out there, I really appreciate you guys hanging out and listening to this entire thing, or 5 minutes of it, whatever you did. Everybody out there, be well, take care, and we'll see you again soon. And thanks again.